Why does the Constitution say so little about the us judiciary? Imagine a document that shapes the foundation of a nation and yet leaves a significant branch of government relatively unspoken. This is the reality of the United States Constitution when it comes to the judicial branch. Why does it contain only brief references and limited details about the courts and judges? To understand this, we need to look at the historical context and the intentions of the framers. When the Constitution was drafted in 1878, the primary focus was establishing the structure of the federal government and protecting individual rights. The framers aimed to create a system of checks and balances among the legislative, executive, and judicial branches. However, they deliberately kept the judicial branch somewhat flexible and less detailed. One reason for this approach was the desire to avoid over-constraining the judiciary with specific rules that could become outdated or limit its ability to adapt over time. The Constitution mentions the judicial branch mainly in Article 3, which establishes the Supreme Court and grants Congress the power to create lower courts. It also defines the jurisdiction of federal courts and the tenure of judges. Beyond this, the document leaves many details to be determined by Congress through legislation. This approach allowed the judiciary to evolve with the nation and address unforeseen issues without requiring constitutional amendments. Another factor is the concern about maintaining independence for the judiciary. By not prescribing every detail, the framers aimed to prevent political interference and ensure that judges could interpret the law based on principles rather than strict constitutional mandates. The limited mention also reflects the belief that judicial power should be balanced and not overly prescriptive, encouraging courts to interpret laws within the broader framework of the Constitution. Furthermore, the Constitution's brevity on judicial matters underscores the importance of the other branches in defining the scope and function of the courts. Over time, Congress and the courts have filled in the gaps, creating a complex legal system that adapts to societal changes. This flexibility has been vital for the judiciary to serve as an impartial arbiter in a dynamic nation. In summary, the Constitution says so little about the United States judiciary because the framers intentionally designed it to be adaptable, to preserve judicial independence, and to allow future legislative and judicial bodies to shape the legal landscape. This approach has helped the judiciary remain a resilient and evolving part of American government.